Good afternoon. I'd like to welcome everyone to Carter's Spring 2025 Charity and Not-for-Profit Webinar Series. My name is Terrence Carter, and I will be your moderator today. We are delighted to have more than 320 registrants join us for this webinar, along with our presenters, Sipa Bani and Cameron Axford. Carter recognizes that its work and the work of its community partners take place on traditional Indigenous territories throughout Canada. We acknowledge the 46 treaties and other land agreements that cover what is called the province of Ontario. We are thankful to work and live in these territories and acknowledge the enduring stewardship of First Nations, Métis, and Inuit people who have cared for these territories since time immemorial and who continue to contribute to the strength of Ontario and to all communities across the province. The presentation handout for today's session was sent to you along with the 24-hour and 1-hour emails that you would have received. And the video replay will also be available on our YouTube channel within 24 hours after the webinar. If you are printing the presentation handout, we recommend that you print up the version that was included with the email sent 1 hour before the start of the webinar. Please note that we have been advised that there will be a system-wide cell phone alert at 12:55 p.m. today. So you may wish to use a desktop or laptop for this webinar. Given the limited time we have for this webinar and the amount of materials we would like to share with you, we will not be able to take questions from attendees. However, we will have a 25 to 30-minute panel discussion after the PowerPoint presentation that will cover a number of the more pressing questions that come up involving this topic. We've also included notes from the panel discussion in the presentation materials so that you will not need to take notes. As background, Carter's is one of the leading law firms in Canada in the area of charity and not-for-profit law and is able to provide a wide range of legal services to its charitable and not-for-profit clients. Carter's has offices in Toronto, Ottawa, and Orangeville. For more information about our firm, please visit carters.ca and sign up for our monthly newsletter. Today, our topic is copyrights and trademarks in a virtual universe, what charities and NFPs need to know, presented by Sipa Bani and Cameron Axford. You have the bio for both, but Sipa Bani is a partner at Carter's and practices exclusively in the area of intellectual property and information technology law. Cameron Axford is an associate at Carter's who practices in the area of intellectual property law and also focuses on Carter's knowledge management research and publication division. Sipa and Cameron will present for about 30 minutes, and we will then move into our panel discussion that I will help to moderate. Please note that this presentation does not constitute legal advice, and attendees are encouraged to speak to their own legal counsel to obtain advice as necessary. I will now hand the presentation over to Sipa and Cameron.
Thanks, Terry, and thanks so much, everyone, for being here today. As we all experienced, COVID triggered an abrupt shift from in-person meetings, services, and events to a world dominated by virtual interactions. Organizations had to pivot rather quickly, and many dove headfirst into this digital space without fully considering how IP law applies to that environment. While, thank goodness, many aspects of life have returned to normal, the reality is that online meetings, classes, and webinars such as this are here to stay, at least in some form. That means IP issues in the digital world continue to be highly relevant and deserve our attention. And as if that wasn't enough, we now have artificial intelligence further complicating the IP landscape, raising new questions about rights, ownership, and usage. We, of course, will not be able to cover everything in today's session, but our goal is to give you a solid foundation in how IP law, including trademark and copyright, applies to your online dealings. We hope this helps you spot potential issues early on within your organizations. As Terry mentioned, at the end of the presentation, Cameron and I will be joined again by Terry for a panel discussion where we'll walk you through some practical real-world examples and the kinds of questions that we get from our clients. I think you'll find that part of the webinar particularly useful. So buckle up and let's get started. So on the slide in front of you, you have an overview of IP rights. Essentially, IP refers to intangible creations of the mind. They are assets, and that is incredibly important to remember. They're assets of your organization, and oftentimes one of the most important assets that your organization may actually own. So the slide in front of you lists the most common forms of IP, but the focus of this talk will be on copyright and trademarks, as those are the most common types of IP that a charity or NFP may own. So establishing who owns the IP in question is very important because if you want to leverage the IP, so for example, you want to enter a co-branding with another organization or a sponsorship agreement, it's important to ensure that the organization first owns the IP in question. Using something that you do not own without permission can violate another's IP rights, and you could be liable for what is known as infringement, which means you're encroaching on their rights or stepping on their toes, and they can sue you for that, which we obviously don't want. We will discuss infringement in a bit more detail shortly. Okay, so let's get into it. So copyright, what is it? Copyright is an intangible form of IP, or in other words, a creation of the mind. It protects every literary, artistic, dramatic, or musical work. Some examples of this will include your logo or your website content, or really any written content that your organization may produce, any music it perhaps produces, any logos or design work. Copyright provides the owner of a work with the exclusive legal right to produce and, importantly, reproduce, publish, or perform that original work. And only the owner of the work is permitted to do this and permitted to allow others to use the work. So moving on to trademarks, what is a trademark? A trademark embodies the goodwill and the reputation of your organization. It is essentially any mark that's used to distinguish the goods and services of one organization from that of another. You all very likely have, a couple trademarks that your organization is using. It can be a word, a design, a slogan, a color, or even a combination of these things that represents your organizations. Oftentimes, it may be your corporate name is your big trademark, or your operating name together with your logo design. Now, a trademark for a for-profit and not-for-profit tend to resonate in different ways with individuals. For example, obviously with a for-profit, when you see the trademark, it helps consumers identify and remember the specific characteristics of that product or service. So for example, you're driving along and you see the large golden arches. An individual would immediately know they can pull up and obtain a Big Mac from that establishment. However, in a not-for-profit context, the recipient of the product or service is not necessarily the one who provides payment. For example, I may donate funds for which another person receives a meal. This kind of indirect exchange often leads to a misconception that not-for-profit trademarks are not as important because donors do not look to a brand to know the characteristics of the product or the service. However, in reality, we know that when the public, sees a not-for-profit brand, they do heavily rely on this trademark. They serve as a shortcut to judge the quality of your charitable services, the caliber of the programs that you're offering, and the credibility of the information. And oftentimes, if you think about it, it is the trademark that will encourage an individual to support or work with, volunteer, or to donate to one organization over the other. Okay, so now that you know the basics of trademarks and copyrights, I want to take a moment to understand the legal implications of IP rights. Copyright and trademark law grants the owner the exclusive right to use their creative work or brand identity. So that means if someone else uses these works or marks without permission, it's considered a violation. Or in legal terms, we would refer to that as an infringement of those rights. Now, this applies not only when others use your organization's protected content without authorization, but it also applies when you use content or marks from others without obtaining proper permissions. So if you copy a third party's artwork or written content, or even maybe their logo, even if it's unintentional, you could be infringing their rights, exposing yourself and your organization to potential legal risks. So in short, respecting copyright and trademark rights, whether they belong to you or someone else, is critical for staying compliant. I'll now turn it over to Cameron to discuss some tips for protecting IP in the digital world.
Thank you very much for that, CPEL, and thank you to everybody for joining us today. So we're going to start by talking about automatic protection of IP. One of the foundational principles of IP law is that some rights arise automatically. For copyright, if the author is a Canadian citizen or a resident in Canada, or a citizen of a country that is party to international IP conventions, the protection is then automatic. That means that the moment a work is created and fixed in some material form, the author holds copyright. There's no need to register or file. Similarly, trademark protection can also arise automatically when a mark is used by an organization. If an organization begins using a name, a logo, or a slogan in connection with its services and builds up goodwill, then trademark rights may be acquired at common law. But, and this is important, while automatic protection is helpful, it's not a free pass. These rights are often harder to enforce, especially online. With the digital world being so fast moving and global, the lack of formal registration can be a real challenge if infringement occurs. That's why we tell clients to always proceed with caution. The next few slides will focus on how to strengthen those rights through registration and policy. While some IP rights are automatic, registration strengthens and clarifies your position, and that can be critical in today's digital environment. Let's start by talking about copyright. In Canada, registering your copyright with the Canadian IP Office gives you a certificate that is official proof of ownership. It creates what's called a rebuttable presumption, meaning that the court assumes you own the work unless someone else can prove otherwise. So this is especially useful if somebody uses your work online without your permission, for instance, reposting a digital guide or duplicating your content on another website. It gives you a clear basis to demand that they stop and potentially pursue legal remedies against them. For trademarks, registration with the IP office brings even more advantages. It confirms ownership and gives you exclusive rights across Canada to use the mark with the goods and services listed with the registration. It's also easier to enforce against copycats or confusingly similar brands, whether or not they are intentionally or unintentionally similar. Importantly, registration of a corporate or business name doesn't automatically grant trademark protection. So if I start the Carter's Foundation, that does not mean I now have Carter's Foundation as a trademark. Many organizations assume that this would be the case, but legal protection only arises if the name is actually used as a trademark and registered as such. So that distinction really matters online, where brand misuse is very common. So let's compare unregistered and registered trademarks. And that's really relevant for organizations who are building a digital brand. Starting with unregistered trademarks. These arise through use, but the burden of proof is on you entirely. You'll need to demonstrate that your organization has built up goodwill and reputation in a specific geographic area. That can often be very difficult to prove, especially with online content, where your audience can be very broad and very scattered across the country or potentially even the globe. So there's no legal presumption that you own the mark, which means any enforcement action, whether a takedown or a court claim, becomes harder and more expensive for you. So let's contrast that with registered trademarks. That's enforceable Canada-wide, regardless of where your audience is based. You'll get a presumption of ownership, which makes it easier to stop infringement, including digital misuse, like unauthorized use of your logo on social media or impersonation of domain names. A registered trademark also becomes an asset. It holds equity and can be licensed or even assigned. That kind of clarity and control is essential when your brand is being expressed and shared online across multiple platforms. Let's talk about policies and contracts. Protecting your IP in the digital world is not just about registration. It also requires good governance at the corporate level. That starts with having clear internal policies and external contracts. For example, an IP policy can help educate your staff and volunteers on what the organization owns, how it should be used, and what restrictions apply to its use. A social media policy is especially important today. Organizations often post content created by multiple people. They can be images, blogs, videos, any type of media. And unless expectations are clear, you may run into disputes about the ownership and misuse of this content. There's also the issue of protecting your own IP, particularly online. By having terms and conditions of use on your website, you can clarify how your materials, such as publications or downloadable resources, can be used by others. And finally, contracts are key. Anytime you work with employees, volunteers, or independent contractors on anything related to IP, be it branding, web content, e-learning materials, make sure that the agreement clearly assigns copyright to your organization and waives any moral rights where needed. That will ensure that the organization, not the individual creator, holds control over the digital assets. So now that we've discussed that, let's talk about some potential traps that you can fall into regarding IP. IP is a major asset, but in the digital world, it can be a huge liability if it's not properly managed. Online content is easy to copy, modify, and circulate, often instantly and globally. This introduces risks. Your content could be used without attribution to you and your organization. It could misrepresent your organization, or it could even be misused in a way that creates reputational harm. That's why organizations need to approach IP with vigilance. It's not just about ownership, it's also about clarity, control, and documentation of that ownership. You should ask yourself, do we have the rights we need to operate our digital channels, like our website, our social media platforms, and our online learning platforms? Do we truly own the content that we're publishing? And just as importantly, are our rights clearly documented and understood by our team and our collaborators? These questions are especially relevant for charities and not-for-profits, which often rely on a mix of internal and external contributors. Without proper controls in place, organizations may find they don't legally own what they believe they do, which can create exposure when you're trying to enforce rights or respond to infringement online. So let's start with the basics of copyright ownership. In Canada, the default rule is that the author is the first owner, and that's usually the person who actually creates the work. There can be multiple authors, but they must be individuals. Organizations cannot be authors of a work. That raises interesting questions in the digital context, especially as we start to see content generated collaboratively or with AI tools. Moral rights are another key feature of Canadian copyright law. Even if the economic rights in a work are transferred, the author can still retain the right to be credited and to prevent distortions of their work. These rights can be waived but not assigned. In the digital space, this becomes particularly important. Say you publish a guide or an infographic online and it's reused or edited by others without your permission. The original creator still may have moral rights over the work. And more broadly, identifying the true author and the chain of ownership becomes more complex in a digital environment where content is reposted, remixed, or shared across multiple platforms, often and sometimes usually without clear attribution. Let's talk about your employees and copyright. One of the key exceptions to the general rule of author's ownership is where the work is created by an employee under a contract of service or an apprenticeship. In that case, the employer, meaning the organization, owns the copyright as long as 3 requirements are met. Firstly, there must be an actual employment relationship, not just an informal arrangement, such as somebody who does work for you just on a volunteer basis. Secondly, the work must be created during the course of that employment. And thirdly, there must not be an agreement to the contrary of the first 2 points. But even when these conditions are met, the author retains their moral rights, as we mentioned, unless they're waived in writing. That's why employment agreements should include IP clauses that address both ownership and moral rights. For charities and not-for-profits, this is especially important when staff are creating digital content like blog posts, videos, online course materials, or branded visuals. These may qualify as copyright protected works. To avoid uncertainty, employment contracts should clearly state that the organization owns all the IP created during the term of employment and that moral rights are waived where appropriate. So now let's compare that to works created by contractors and volunteers, because this is often where things go wrong for charities and not-for-profits. When you engage an independent contractor or a volunteer, the default rule is that the creator, not the organization, owns the copyright. That applies even if you paid for the work in the case of a contractor. The key issue here is whether the person is working under a contract of service, i.e. as an employee, or a contract for services, i.e. as an independent contractor. Courts will look at the nature of the relationship, and most volunteers, freelancers, or short-term contributors will fall outside the employment category. That means unless there's a written agreement assigning the copyright to your organization, you may not actually own the rights, even if the content appears on your website or was created specifically for your organization. This is a common trap in the digital context, where organizations rely on external help to build websites, design logos, or create e-learning tools. To avoid disputes, your contracts should clearly state that the organization owns all deliverables and the copyright is assigned and that moral rights are waived. Otherwise, you risk losing control over the very content that defines your digital presence. So I will hand it over to CPAL to take over.
So with respect to trademarks now, once a trademark is used or displayed to the public, the trademark owner starts to accrue common law or unregistered trademark rights. So the first user of a trademark in Canada is technically the person that's entitled to register, own, and use that specific trademark. And the scope of protection for common law or unregistered rights is really restricted to the geographic area where you have a reputation, whereas with registration, it's effective throughout Canada, regardless of where you're operating. So as previously mentioned, for unregistered common law trademark rights, you have to show extensive use, reputation, and goodwill in the mark to rely on these rights. There's no presumption of ownership. So what that looks like in the practical world is even if you've been operating, say, for 20 years and someone manages to get a registration for your particular name, corporate name, and comes to you with a cease and desist letter and asks you to stop use, you would have to go to court and prove through extensive evidence that you have a reputation using that mark in association with your services, that you have goodwill, and your rights are really precluded to the geographic area where you can show that. So without having that registration certificate, there's no presumption of ownership. Whereas if you have the registration certificate, it's presumed that you own it. And in trademark law, we refer to that as an absolute defense to an infringement claim. So as organizations build their presence online, it's important to recognize that using trademarks in this digital space comes with a certain set of unique risks. So this includes things like domain names or domain name squatting, social media handles, and that sort of things. All of which are highly visible and often closely tied to your identity. So if someone else registers a domain or a social media handle that perhaps includes your mark or something confusingly similar, it can mislead the public, it can dilute your brand or even damage your reputation. That's why it's so essential to actively monitor how your trademarks appear and are being used online, both by your team and by third parties. So quickly detecting this misuse or infringement allows for faster response, whether that's through platform takedown tools or other forms of action, which we will discuss shortly. So the best thing that you can do to avoid legal issues online or otherwise with trademarks is to search, register, and control your trademarks. And this is something we tell our clients every single day. So the first thing is the search. So searching really allows you to avoid stepping on others' toes. And you can determine who is potentially stepping on your toes as well through these searches if in fact you have pre-existing rights. So you need to hire legal counsel to do very robust, comprehensive searches that search not just the trademark database, but also look for unregistered use of the mark. We already discussed the importance of registration a bit, but essentially registering your mark provides you with offensive and defensive tools in your toolbox. It can be used defensively as a shield to help ensure your trademark rights are not easily challenged, and offensively as a sword if someone is stepping on your toes. Lastly, regardless of registering a trademark or not, it is of vital importance to make sure that you control any use of your trademarks. So what does that mean? That means license agreements are in place when a third party is using your mark. It means using your trademark properly and consistently. And it also means that when there is a third party unlawfully using your mark or confusingly similar variation, you stop that use. All of these things are very important to ensure that your mark can withstand future challenges. So another issue that we've seen is with the use of third-party material. So generally, staff volunteers may not realize all of the complexities and nuances associated with copyright protection. A very common occurrence is the use of what is known as collective licensing, such as Christian Copyright Licensing International, for example. And what they do is, it's a great service. They sell copyright licenses that allow you to use music during services so that you can, pay out one licensing fee and be able to play that music. However, what is often misunderstood is that this does not automatically mean you can live stream your service. It also doesn't mean you can record it and post it on YouTube after. So in fact, many of these licenses explicitly state that they do not cover streaming of content or recording and posting on YouTube. There may be licenses that include those activities, but you have to be very careful and see what exactly you're purchasing when you purchase the license. The same thing goes for images for your website, for example, from third parties. You have to determine when you're purchasing that image, what sort of rights you're obtaining. Is it permissible to post it online? Can you post it on a website? Or is it only simply to use it internally? So therefore, we always tell our clients before you go online, you really need to investigate what exactly you're permitted or not permitted to do with the content that you've purchased. Okay, so let's turn over to social media, something I'm assuming that most of us interact with daily, either personally or professionally. Whether it's, LinkedIn or Facebook, Instagram, YouTube, these spaces are full of content. And the content is often protected by copyright or trademark laws. So, don't get me wrong, I completely understand and agree that social media can be an extremely powerful tool for communication and engagement. But it also comes with some risks. So one of the biggest is the potential for infringing intellectual property rights. So for example, if someone on your team shares an image or a video clip or an article, a logo, for example, without securing the necessary permissions, your organization could be exposed to liability. And the same goes for third parties who might post or tag your content intentionally or sometimes even unintentionally in ways that could potentially violate your rights. So that's why it's so critical to make sure you're monitoring your organization's social media presence. You want to keep an eye on, the things that are being posted by employees on your official channels and watch out for third-party content that also may be misusing your content. So whenever content is posted, just stop and ask who owns this, because if your organization doesn't hold the rights, reposting it or sharing that content might very well amount to infringement. The good news is that most of these platforms now do have very effective mechanisms and takedown tools for, reporting issues to help address these things. And I'll get into those a bit later in the panel discussion at the end of the session. So now moving on to the hot topic of AI. I wish, in times like this, we were all live so I could ask you guys how many of you use AI in your organizations. But I think the reality is whether you've made an organizational decision to use AI or not use AI, many of your employees or volunteers or contractors will be relying on these tools. And it is a game-changing technology. It's rapidly reshaping the creative digital landscape. These systems like ChatGPT, which is probably the most common, they can produce content across a range of media: text, logos, images, music, poems. The other day I used ChatGPT to do some, design work at home, and I was truly blown away by what it produced in such a quick, just by taking a quick photo of the area. And the scary thing, or good thing, however you want to look at it, is that often the level of quality that we can get from these systems can rival that of skilled human creators. What's particularly striking is how little input is needed. A short prompt from a user can result in complex outputs within seconds. Behind the scenes, these systems are powered by large-scale machine learning models, and they're trained on these huge, massive data sets. So these data sets can be texts from books, website, or images scraped from across the internet. So what happens is, through these training, the models learn patterns and structures that will allow them to mimic or remix creative styles and formats. And with the rise in this capability, however, comes a rise of concern, legal concern in particular. Many in the creative industries, authors, artists, publishers, brands, they're questioning how this fits into our current IP framework. Who owns that output? Was the training data used lawfully? Are these systems indirectly infringing on copyright or trademarks owned by others? These are massive, complex questions, and we won't solve them today, obviously. However, it's important to flag the growing legal and ethical discussions around AI-generated content, especially as your organizations begin to use or encounter this technology more frequently. So, as you are using AI or considering using it, it's important to remember that AI-generated content is not automatically protected by copyright. As Cameron mentioned, in many countries, including Canada, copyright law requires a human creator. So that means that AI outputs may not be protected at all. We're seeing some of these cases flow through the courts in the US, and likewise will happen in Canada as well. But for the time being, we have to remember that what is created from AI is not protected by copyright. The ownership, where does it rest? We don't really know. It could rest with the platform and not the user. Charities and NFPs need to review the platform terms. Many of them do grant broad rights to the provider, limiting how you can use the content. Another thing is that AI tools, we've seen this with clients, can generate logos, slogans, brand names, all that kind of stuff. And these sometimes closely resemble existing trademarks, creating the risk of an unintentional infringement. So you just need to be aware of the use of, this unauthorized or sometimes biased sources that come along with AI. So AI models are trained, like I said, on these massive data sets, and they probably include copyright content or even inaccurate or unreliable, outdated material. So this can, of course, lead to legal exposure and reputational harm. So the key takeaway is to always vet your AI tools before you use them and understand the IP terms, and be cautious if you're incorporating AI-generated content into branding or public materials. And actually, what I've been telling our clients, it is way too risky at this stage to use AI to create any sort of IP assets. So stay away from it if you're trying to create content or logos, that sort of thing. It's not reliable, and you could be sued for infringement. So finally, I'll just wrap up this portion of the webinar by saying, I think it's probably evident that all charities and NFPs do own some form of IP, be it copyright or trademark or a combination of both. And that IP, it's a very valuable asset of the organization, and it's important that it be properly used, protected, and enforced to avoid unintended consequences, both online and offline. So that concludes the slide portion of our webinar, and we'll now move on to the panel discussion.
Great. Well, thank you very much, Sepal and Cameron. Really good materials that you provided. So yeah, let's move over to the panel discussion at this point. And I have some questions for you on behalf of everyone in the audience. Sepal, in recent months, you and I have assisted many large international and national charities and NFPs proceed with rebranding. And I'm wondering what sorts of things come to mind that would be of help to organizations thinking about either revitalizing their brand or adopting a new brand.
Sure. Yeah. And I mean, I think that is kind of a timely thing right now. It seems like we do have a lot of, clients that have had brands for 20 plus years that are revitalizing, rebranding. And I guess the first thing I would say is before you fall in love with a new brand or new trademark, you should do a full comprehensive search and get a report from a trademark council regarding whether that name or the logo, the branding, it's already taken. We want to look at not just identical existing marks, but also confusingly similar marks in your similar sector. So, that's a big one. Remember, it doesn't need to be identical. It only needs to be confusingly similar to be a problem. So phonetic equivalents need to be examined as well. And if you do your comprehensive search and everything checks out, the next thing you want to do right away is to get your your applications in the pipes with the Canadian Intellectual Property Office as soon as possible, because Canada is a first to file system. Although rights always go to the first user, there is a very big, significant procedural advantage to filing first. So get those applications in. We want to also think about securing your socials and your domain names. If you have international reach, which, is very common now because we're online, you're transcending borders, you want to think about doing similar searches and applications in the USA and any other jurisdiction you may be working in. You also want to think about your copyright because, as Cameron discussed, if you have a contractor that is designing logos for you or branding, it may be that they are the owner of those rights. So you want to make sure that you have a clear assignment of the branding to the organization and a waiver of moral rights. Terry, I find, and you always discuss this with clients, is that rebranding often raises questions from donors or staff in the public. So you need to be ready to communicate the why behind the change and show how the brand really reflects your mission and your future goals. And lastly, I would say, and most importantly, first use is everything in the world of trademarks. So you need to work closely with your legal counsel on how to accrue rights in that new brand before your official launch date.
So just on that point, you're talking about choosing a new brand, protecting it, but then using it prior to the launch. So how would you use it, Sepal, prior to the launch?
Yeah, so that can be done in strategic ways. You can have kind of, a secondary page on your main website to show, to have that trademark displayed with some services that you plan to offer. You may have, your new domain name that's up there. It doesn't have to say that, you're rebranding to this, but just that the trademark is up there on a domain name in association with your particular services. So there are, kind of strategic ways to do that. And yeah, the trademark lawyer will be able to kind of guide you through that.
So we got a new brand we're thinking of for the organization. But what about the brand that's been in place for many years, the legacy brand? Are there some steps that need to be taken in order to protect the legacy brand?
Yeah, thank you, Terry. So that is really important. You don't want to abandon your legacy brand because as soon as you abandon it, a third party can take over that goodwill, that you've developed over the last 20, 30 years. So you want to maintain that like legacy brand, even though it's not going to be your main brand to the public. And again, there's strategic ways to do that with minimal use. And also things like maybe registering a business name for your legacy brand. So again, you want to kind of do this in strategic ways so that you're protecting the legacy from usurpers.
Great, thank you, Sepal. So Cameron, over to you. Sort of thinking in situations where brand IP may be misused in other jurisdictions that are not, as easy to seek recourse against. So what do you do about organizations when intellectual property is being misused by entities in jurisdictions where enforcing IP rights can be challenging, like in China, for instance? Can you walk us through some of your thoughts?
Thank you, Terry. Yeah, and just to provide some context to the audience, as I touched on briefly in the presentation, there are international treaties and conventions which allow for nations to mutually recognize IP rights. So if there's a treaty nation and Canada is a signatory with them, if my brand is misused in that other treaty nation, their government will enforce my rights on behalf of the Canadian government and vice versa. But not all countries on Earth are a part of those conventions, and there are some particular jurisdictions where they are parties to those conventions, but for one reason or another, the legal systems are not efficient in protecting IP rights. So if you do find yourself in a situation where your IP is being misused in a jurisdiction like that, there's a few different steps you can take. The first thing we would usually recommend is a cease and desist letter, which is very standard, and I believe CPAL is going to explain in depth cease and desist letters in a few moments, so I won't go too in depth into that. But what else you can do is there's takedown enforcement through internet service providers, or ISPs. So ISPs have the ability to control the content and disable the use of their services. ISPs, if you don't know, they're the ones that provide websites with the website. Virtually all ISPs adopt policies to address the use of their services. And enforcement through ISPs is often faster, more effective, and less costly than traditional enforcement like a cease and desist letter or going to court. This is an effective manner to enforce your rights within international jurisdictions. And in addition to ISPs, you can also do something similar with Google and other search engines. So if your IP is being misused in a difficult jurisdiction, let's say it's being used to sell some sort of product, you can go to Google and explain to them how your IP is being misused, what laws are being broken, and request that Google delist that content, meaning that if somebody goes and Googles that product, it will not show up on a Google search result. So there's also takedown enforcement for social media. Perhaps your IP is being misused on a social media platform in a difficult jurisdiction. So each platform, be it Facebook, Instagram, TikTok, whatever it may be, each platform uses different technology and will provide different information points to offer a takedown procedure, but they will all have takedown procedures, ways similar to the ISP procedure that I just mentioned, in which you can request that offending content be taken down. For social media particularly, we recommend to clients that you need to capture and preserve all available evidence. So if you see that your IP is being misused on a social media platform, make sure you take a screenshot or a live capture of that web page as it is when you find it, because on social media platforms, pages can go private. They can be made only available to members of particular groups on the platform. And that can result in your IP being misused, but it's not visible to you. So make sure that you capture and preserve all evidence for your own records, but also to bring to the social media platform to demonstrate to them how the IP is being misused, and then the offender can't slink away into a private group and keep doing what they're doing.
Great. Okay, Cameron, thanks for that. I want to switch over to everyone's favorite topic of AI. So Cameron, what are some of the risks with respect to the use of AI as it relates to IP? And then, Sepal, if you want to follow up, maybe you can walk us through some of the risk mitigation techniques that would be available. So Cameron, over to you.
Great. So we already talked about how essentially ownership is unclear, so I won't go into that. I'll touch on some other topics. So some risks which AI produces are AI deepfakes and brand misuse. AI can generate fake videos, voices, or images of your potentially members on your board of directors. They can create fake images of events that you never had. These deepfakes, they can mislead your donors, damage your reputation, or erode public trust, especially if they appear authentic, are shared widely online, or touch on some sort of controversial or inflammatory topic. There's also the issue of automated IP infringement. So AI can be used to mass produce counterfeit virtual goods, logos, or branded materials, mimicking your organization's IP. And this can happen faster than enforcement tools can keep up, especially across multiple platforms or jurisdictions. And there's also licensing and terms of risk use, which we have touched on, but some AI tools include restrictions in their terms of use that limit commercial or public-facing applications. So, and I'm sure CPAL will get to this in a minute, but always check the terms of use of any AI product that you intend to use. So over to you, CPAL.
Yeah, well, I think, the only way to really avoid risk is you don't use AI for, certainly not for IP creation, don't go there. The other thing is with respect to if you're using AI, for other things like maybe internal documents, that sort of thing, you just want to have clear policies regarding the use of it. You likely want to have some sort of requirement for disclosure so that if employees, volunteers, or contractors are using or creating using AI, that they have a positive obligation to disclose that AI was used so that at least you're aware. When you're getting your IP assets created, you want to have contracts that state that the IP is created by an individual and not using AI platforms. And then with the logos and trademarks, we always say do the search, because then you'll see if there's anything confusingly similar out there, and that, also helps you mitigate any risk.
Okay, great. Thanks, CFO. You may not know about it, but the Carter's Foundation, a brand new small charity incorporated and set up today, uses a free AI design tool to create a new logo for its virtual fundraiser, which will be tonight. 6 months later, we receive a cease and desist letter from a major retailer. The AI created logo resembled a registered trademark for similar services. Cameron and CPAL, can you please let us know what the outcome of this could be and how to avoid this issue in the first place?
Sure, so I'll take the lead on that. Liability still falls on the user. That would be the charity or not-for-profit, not the AI. AI is a tool, it's not a legal shield. If you breach copyright or trademark law, you can't say, oh, well, ChatGPT, for example, made that, not me. You can still be sued for infringement, even if it was unintentional. So in this case example, the Carter's Foundation is going to have to immediately stop using the logo. They're going to have to rebrand their event, likely at a significant cost, and it's going to set their virtual fundraising goals back by 6 months.
Yeah, and I'll add, I guess the lesson here is to avoid this issue, Carter's Foundation, do not rely on AI for logo creation at all, ever.
That's simple. That's great. Thanks, CPAL, for that. Cameron, what policies do you think charities should consider putting in place before using, if they do, AI-generated content in either fundraising or public-facing campaigns?
Yeah, so if Carter's Foundation ignores our advice and goes ahead anyway and uses AI to make IP, best practices include you're going to, first of all, we highly recommend that you have an AI policy. That will be a comprehensive policy which is going to outline how your organization allows or disallows the use of AI, what particular AI programs are allowed, and who can use it in what particular instances. And that's very important that you develop an AI policy. Further, This AI policy should include a content review and approval process that will ensure that all AI generated outputs go through a human review before publication to catch any factual errors or misrepresentations. You're going to want to review the license of the AI program to make sure that you actually own what the program puts out and not the company that owns the program. And then finally, you're going to want to have ethical and brand considerations for any use of AI. You're going to want to include standards in your policy to ensure that the AI use does not generate content that could conflict with your charity or not-for-profits organizational mission, mislead donors, or undermine trusts with your donors and the public.
Good, thank you, Cameron. Sepal, you know, we often have clients that come to us because someone has misused their brand in sort of a virtual world context like Meta. So what sort of options would these clients have that you could advise them on?
Yeah, I mean, one thing, Terry, that we have been getting a lot also is clients are receiving cease and desist letters from organizations like Pick Rights for using images that they found on Google. So that's a common thing that, you know, we've probably all done, we all do. You go to Google, you go to images, you grab an image and you use it in your newsletter or whatever it is. And then all of a sudden you're slapped with a cease and desist letter from Pick Rights. And, you know, Pick Rights is saying you have to pay $1,500 the next 10 days, or they're going to start, you know, a court action. And what I would say is, these are real letters. This is a real problem. So you do need to take it seriously. You need to hire a lawyer. You need to respond. You know, we've had some good news situations where we've been able to settle with Pick Rights, but still you have to hire a lawyer and go through the whole process. So you just need to be really mindful of that. Just because it's on Google doesn't mean you can lift it and use it. Even if you're a charity or a not-for-profit, you still have to make sure that, you know, you're permitted to use that image, and oftentimes you are not. So just flagging that one, because we are seeing that, you know, time and time again right now. So moving over to your question, Terry, about what you can do if someone misuses your brand on socials. You have several options. So you can file a takedown request on the platform, which Cameron has talked about. And this is something, you know, 5 years ago, the social media platforms were not really moving on, but now they have positive obligation through US laws to take down content that is infringing. So there's specific forms for copyright and there's specific forms for trademark. And if it's a legitimate claim, they will take down the page or content, you know, usually within 24 to 48 hours. So that's a great tool that we use all the time. Another one is sending a cease and desist letter, which is a very common tool that we use as well. Typically, the first letter is warm and fuzzy, asking them to stop, please. If they don't, then we kind of ramp it up and try to get them to take down, you know, the material that they're unlawfully using. There's also domain name proceedings, which we're using, you know, a lot more now. So if someone is sitting on a domain name that is confusingly similar to a registered or unregistered trademark that you have prior rights in, there's proceedings to take back ownership of that domain name as well. But what I will say is, regardless of whatever tool you use, whatever route you take, you should really consult with legal counsel, because you don't want to do something that may inadvertently jeopardize your rights. So before we do the takedown or the cease and desist, we always make sure that your rights predate the infringer's rights, because if they don't, you could be, you know, awaking a sleeping giant, so to speak. So.
All good points. Thanks, Sepal. Both of you talked about sort of automatic rights, copyright and trademark, but what about registration? When is it a good idea to actually move ahead with registration, particularly of trademarks?
Sure, Cameron, I can take this one. So, you know, often the first question, Terry, as you know, we ask our clients when it comes to proceeding with registrations of trademarks or copyrights is, do you care? Do you care if someone else uses this content, this trademark? If yes, then you should consider and seek registration, be it copyright or trademark. Things like, your corporate name or your brand, your logo designs, things that kind of are what we would describe as key assets, you should consider registration of. If it's a work or brand that's central to your organization's identity or its activities, its services, registration is a very smart, proactive step that, you should take to protect it. The only time that I, tell clients to stop and think is that if you're using a logo or an evergreen kind of copyright content that's going to be changed and amended, then you want to hold off on the copyright and trademark registration until, that work is in final form, because once we file, there is no amendments permitted.
Right. So I'm part of a small organization, don't have a large budget. I'm listening to what you're saying and Cameron's saying, and I'm thinking, how can I do any of this when I'm working with a small budget? Are there some practical suggestions you can give people about how to accomplish something in relation to protection, but do it on a budget?
Yeah, I mean, absolutely. And that's, such a common and very valid concern, of course. So for smaller and newer organizations, or even like a large organization with a very limited budget for IP, there's, a lot of practical things you can do internally, and only bring in counsel, when necessary. One thing we always tell these, clients is to prioritize what they're registering. So you don't need to register all, 10 of your trademarks at once. You can start with your core brand, which often is your corporate name, and then kind of build from there as resources allow. Internally, you want to keep really clear records, because if you're relying on unregistered rights, we really need those records. Consistent branding is very important to trademark rights as well. So you want to always be using the trademark in the same manner and, with a trademark symbol if possible. And you want to secure, what we refer to as your digital assets early on. So your domain names, your social handles, your usernames, all of those things are pretty inexpensive usually and critical, and, much cheaper to register a bunch of domain names and try to take back ownership at a later date. And lastly, I would say, most organizations have to have contracts in place for other things anyway. So just use those contracts wisely. So if you have employment contracts or contracts with contractors, volunteers, or collaborators, just ensure there's IP provisions in there that, ensure that you own the protection, or, you own the IP in question.
Thanks, Sepal. Cameron, you got the last question. We're down to the last couple of minutes. How can an organization distribute to the public its copyrighted protected material while retaining control of the material in 1 minute or less? Cameron.
Yeah, so the best approach is a written license agreement. That way you can clearly define how the materials can be used, who can use it, and under what conditions, including attributions or limits on commercial use. Another option would be Creative Commons licensing, but you still need to carefully choose on how much control you want to keep, as there's different levels of Creative Commons licensing. For charities especially, it's critical to remember that IP is a charitable asset. Under Canadian charity law, you can't just give away your assets to non-qualified donees. That could breach the Income Tax Act. So any distribution must align with your charity's purpose, and it must preserve the value of the asset.
Thank you, Cameron, for staying on target. Just want to go back to the materials which we're going to be handing out, or are available for handout. So we've done the panel discussion. For those of you like me who don't like to make notes, we made notes for you. So all of the questions that we've addressed during our panel discussion are here in the materials, together with notes from both Cameron and Sepal. So thank you, Cameron and Sepal, for putting those together and making the lives of our attendees just a little bit easier to be able to go back and take a look at. And again, the video will be available in 24 hours time. Finally, we do have a resource page, which has a number of different helpful materials. An extremely popular book, sold out all the time on Amazon, Branding and Copyright, co-authored, is available. there's just a few copies left anywhere in the world, but you might want to pick one up. And then we have some articles that Sepal and Cameron have put together. They're excellent with regards to different aspects. We do have a checklist that we put together, a legal response checklist, which includes IP and online content issues. So those are good resources to help you with your particular organization. Just a little plug, we do have another webinar coming up on June the 3rd, dealing with key legal and operational issues for donor advised funds. So if you're in that area of interest, then do please come and join us that day. And then we have the bios for the three presenters, Sepal and Cameron. So information about them as well. And then of course, everyone's favorite slide, the disclaimer, none of this constitutes legal advice, but hopefully it has been of interest to you and of help with your organization. So I want to thank Sepal and Cameron for the hard work putting together the materials and for your presentations. It was excellent. Thank you, Sepal. Thank you, Cameron. And with that, we're going to end our webinar on time, right on time at 1 o'clock. Thank you very much for everyone participating today. And we'll be having more webinars come up in the future. Thank you again for joining us.
Thank you. Bye-bye.